Thank you all for joining us this evening. I'm Julia Robbins, Senior Vice President with CAMCO. We also have Christina D'Annunzio, our Chief of Staff with CAMCO. And tonight's presentation is on the Corporate Transparency Act and PA Act 122 and the implications on your community association. Our presenter this evening is Stefan Richter of Clemons, Richter, and Reiss. Just so everybody is aware, the Q&A is enabled for any questions that you may have throughout the presentation. We will make sure that we moderate any questions that you may have to Stefan during the presentation. If we are unable to get to your question, please reach out directly to your community manager and or supervisor, or also your community association's attorney directly. So without further ado, I will turn it over to Stefan.
Thank you, Julia, and thank you, Christina. Good evening, everyone, and thank you for allowing me to come into your living rooms or kitchens and speaking to you about the Corporate Transparency Act and PA Act 122. The Corporate Transparency Act is a federal statute that will probably take up a majority of this presentation. PA Act 122 is a state legislation creation that amends the nonprofit corporation law and adds a new reporting requirement that previously did not exist. And we'll talk about that toward the end of the presentation. And of course, ask questions during the seminar. Julia will send them to me or just read them out loud, and I will try to answer them as they are received. Since I can't see any of you, it'd be beneficial to make this as interactive as possible. I stole this slide from the law seminar in Las Vegas and gave credit to, I got ahead of myself. Corporate Transparency Act and what is FinCEN? Corporate Transparency Act is essentially a federal statute intended to curb, prevent, and govern money laundering, corporate theft, and add transparency to the controllers of various corporations so that the government knows whether international money laundering is taking place, who are the players in these large financial transactions, and whether money is being laundered. There's also talk about all kind of other trafficking going on. And this has been in discussion since approximately 2006. There was a Financial Action Task Force. Transparency and Law Enforcement Assistance Act was enacted in 2008. And then it morphed in 2019 into the Corporate Transparency Act and its introduction. It was introduced in 2021. And quite frankly, no association or nonprofit organization paid much attention to it because it was not originally intended, or at least no one believed that it was intended to govern nonprofit corporations or community associations such as ours. But we did find out when we asked for an exemption that it was intended to be, or at least intended to be applied to community and condominium associations, and hence the need for these presentations. In any event, the CTA was enacted in 2021. Rulemaking took place in 2022, and is it still taking place today? It went into effect January 2024 for new corporations, and we will talk about the compliance deadlines and what it means for your association. So a little bit of an acronym: CTA, Corporate Transparency Act, and FinCEN. FinCEN is an acronym for an agency of the U.S. Department of Treasury, Financial Crime Enforcement Network, FinCEN. It is, again, an agency of the Department of Treasury, and it collects and analyzes financial transactional information and keeps a record of it. Its purpose is to combat domestic and international money laundering, terrorist financing, and other financial crimes, all of the things for which community associations are known for. I said that in jest, of course, but that is the the goal of the Corporate Transparency Act is to combat domestic and international money laundering. So how does FinCEN apply, or the CTA apply to associations? So the application of the Corporate Transparency Act, it applies to what are called reporting companies. We'll talk about what is a reporting company. And it requires that each reporting company registered all beneficial owners. And that is where you as board members and management company employees and treasurers come in. And once the obligation is set that you are a reporting company as an association and that you have registered your beneficial owners, the CTA also applies that information needs not only to be reported, but also periodically updated. What is and who is a reporting company? Officially, it is a domestic reporting company, is a corporation, limited liability company, and any other entity created by the filing of a document with a Secretary of State or similar office in the United States. So what that means for most associations in Pennsylvania is that if you are incorporated at all under nonprofit corporation law, you're considered as an association to be a reporting company. That is not the case for unincorporated associations. They are not considered a reporting company, although we do not have case law or formal confirmation from the CTA as to whether or not unincorporated associations need to comply with the CTA. We are thinking as of this time, the answer is no. Confirmation has not been received. So again, reporting company, and there are 23 types of entities that are exempt from the reporting requirements. And while I will not list them here today, there is one that could potentially apply to associations that are considered large operating company exemption. So the CTA does not look for or isn't intended to govern money laundering by giant corporations because they have other federal reporting companies. The CTA is really more concerned with smaller operators where money could be hidden or terrorist funding could be funded through. So if an association is a large operating company, it could be exempt from the reporting requirements if it meets all of these requirements. It has to have 20 or more full-time employees. The association has to have a physical office in the United States, which is going to be true for, I think, all of us. And in the previous year, it must have reported greater than $5 million in gross revenue on its IRS forms 1120 or 1120S or 1065. So I know of at least a few Center City, Philadelphia associations that are condominiums that have 20 or more employees. Obviously, they have an office in the US, and their annual revenue is far in excess of $5 million. So those associations would be exempt from and would fall under an exemption to CTA requirement. However, most of my clients will not be qualifying for this exemption. Who are beneficial owners? Assuming, of course, you are a reporting company or your association is a reporting company, you must report your beneficial owners. Beneficial owner is defined as follows. Any individual who directly or indirectly exercises substantial control or owns or controls at least 25% of the ownership interest of a reporting company. So that's important for a declarant or a large investment group. Substantial control is also defined, and it must meet these one of these criteria. An officer or senior officer, all board members are, well, at least the ones that have an officer position are officers. Individual has authority to appoint or remove officers. That's a corporate designation issue. It's going to be governed by your bylaws, not normally applicable to the association or any association. But here's the sort of catch-all, an important decision maker. And as a board member, you are one of 5 or 3 or 7 important decision makers. And you have any other form of substantial control of the reporting company. So those are the 4 criteria. So in addition to any board member, if you have an assistant treasurer that has authority to bind the association, or I believe that if you are a management company employee that has check writing authority, also required to report as a beneficial owner of that association. Beneficial owners therefore likely include board members, any officer and director that is not a board member, and some of your bylaws will have provisions in them about assistant officers, assistant directors, treasurers need not be board members. So they are we've included as beneficial owners. Any owner that holds more than a 25% interest in lots or units. Again, the declarant will, at least during build out, there are associations that still have large investment groups that own a significant number of units. They will have to report, even though they may not be on the board. That is going to be a challenge for associations to get those owners to report, but nonetheless, it's a requirement. And I also believe some of the managers, depending on the terms of the management contract and the manner in which financial access and control is governed. Reporting company information. What is the list of information, documents, things that need to be provided? FinCEN requires that the reporting company give its full legal name, easy. Current US address, also easy. I think state or jurisdictional information will be easy for us. It's going to be for most of you here in Pennsylvania. If the association should have an EIN number. And that is essentially the only thing that is required of the reporting company. And if we have a little bit of time, we can show you later as to where that information is. But I believe that your management company, CAMCO, will be following up with instructions and will be handling this matter for you. So you probably don't need to get into the nitty gritty and how to actually do the work. I think this discussion is more for what does the reporting who is a reporting company? What does it need to report? Who is a beneficial owner? And what does a beneficial owner need to report? So these are the requirements, the 5 requirements for the reporting company. Okay, and then we are in the beneficial owner category. So if you were a board member listening to this, this is what a board member needs to report as a beneficial owner under the CTA. Full legal name, easy. Date of birth, also easy. Complete current address, and a unique identifying number of one of the following non-expired documents. U.S. passport, driver's license, any other kind of state or tribal ID. Don't know if anybody has a tribal ID, but I've never seen one. And that is the information that FinCEN will be holding for each board member. That is the information that as a beneficial owner, you need to be prepared to submit. So I want to dispel the notion that you need to give your social security number. You do not. You do not need to provide anybody with your social security. It's name, date of birth, current address, and a copy of one of these type of identifications. So I myself have gotten a FinCEN ID because I wanted to try it out. It's a website you log into and you provide a login and password, and then you can give them your full legal name, you type in your date of birth, and you upload a copy of your driver's license. So the FinCEN ID can be obtained here. And again, I think your management company will be doing this for you, but I wanted to just make sure that you knew how uncomplicated it is, even though the entire process is burdensome. And we'll talk a little bit about constitutionality and how this is going to impact future board members from wanting to run. But in any event, the FinCEN ID can be obtained by logging onto this website. And then what FinCEN will do is when you log on to the website and get your FinCEN ID, you will get from FinCEN a 12-digit unique code. has nothing to do with your driver's license, has nothing to do with your social security number or your birth date. It can't be reverse engineered. At least we don't think it can be reverse engineered to get your personal information, but it is a 12-digit number that you can then use as a board member to report to CAMCO, or the entity CAMCO will be using to submit the reporting information to the CTA. So again, the information that is required of you to report, your name, date of birth, address, and one of these IDs can be submitted in one of two ways. The first one is you get yourself a FinCEN ID, which you can do on your own. And the second is that you provide that information to CAMCO, or the entity that CAMCO will be using to report under the Corporate Transparency Act. So I don't know if that's clear enough, but those are the two pathways. So if you don't feel like sharing a copy of your driver's license with your property management company or the entity that your property management company will be using, you can go ahead and get yourself a 12-digit number, and then you could submit that 12-digit number in lieu of having to provide personal information such as date of birth and driver's license number to the management company or its vendor. So what the FinCEN ID does then, it relieves the filer from gathering or keeping the information, so that, for example, if I have agreed to do this as attorney for some of my clients. So if I ask them to get FinCEN IDs, I don't have to gather and maintain and keep secure their driver's licenses and birth dates. All I need from them is the 12-digit number. So it relieves me from having to keep those records, and it relieves you as a board member from having to produce those records. Again, CAMCO will be instructing you as to how it prefers to report this information, but it can be done in one of those two ways. And I think the hardest part about getting a FinCEN ID is finding a teenager that is capable of taking a cell phone picture of your driver's license front and back and uploading it onto the website, with which I had quite a bit of trouble until I figured out how to do that and email it to myself. But that is really the hard part. Okay, so now that you're a reporting company and now that you're a beneficial owner and you have figured out what information is necessary and whether you want to give a FinCEN ID or direct report, the current deadline, I should say, for compliance with the Corporate Transparency Act is December 31st of 2024. So existing companies that come into play after January 2024 already had to comply with this. However, I shouldn't say that. I think I misspoke. Corporations that came into being after January 1st, 2024 already had to comply with this, and there is a reporting deadline. Existing associations and corporations have until December 31st, 2024 to report. And that is why we are giving advice that while we should be prepared to report, while we should be prepared to have our candidates who want to run for board members to report, we're not running to be the first ones to report. And there is a couple of reasons why. One is that Congress is currently working on a 1-year extension for the application of the Corporate Transparency Act. And I believe that the House has adopted and passed a vote to extend, but the Senate has not. And that you can probably get a copy of this presentation, but there is a basically a Grassroots Community Associations Institute website where you can send a letter to your senator and representative to support an extension. So the one thing that is currently in the hopper is, again, an extension for implication or for application. Once the reporting has been done and we are sure that we have to comply by December 31st, anytime you have an election, anytime you have a resignation, within the management company or on the board, that information is required to be updated within 30 days of the change. So those are the deadlines for reporting and for updating under the CTA. The penalties for non-compliance are intended to be severe. Penalties including $500 a day, fines up to $10,000. There are criminal penalties also. What I'm not clear of yet is how the federal government intends to know who is not complying and then to enforce against literally millions and hundreds of thousands of associations and small corporations that need to comply with this. I would expect, and I'm not making a prediction here, but I would expect that if an association or a small corporation has not filed and the Department of Treasury has found out where you are and who to contact, they will probably send you a letter that says, you need to comply with this. I'm going to give you X day to comply. Otherwise, these filing penalties are going to be imposed. So I don't think that the hammer is going to come down on the entire country on January 1st, 2025. But that does not mean that we should be waiting. I just think that the some of the confusion about who does it apply to, are we exempt, is there going to be an extension, who is a beneficial owner, and what if a board member doesn't want to produce the information, or what if that owner who is an investor owner and owns 25% doesn't want to produce the information and you partially report, will we automatically be liable for $500 a day and $10,000? My prediction is the answer to that is no, and that there will be some compliance period. There will likely be some notices. We just haven't seen them because it hasn't come to be effective just yet. But be advised that these are the potential penalties. So what are some of the practical considerations? I think as board members, you need to be prepared to get yourself a FinCEN ID and or be prepared to give the information to CAMCO in order for the association to comply with the Corporate Transparency Act. Corporate Transparency Act is a federal statute and it is a mandate. It is not discretionary. So if you want to be a candidate for an association board or want to continue to run as a board member, you must comply with this. Although our bylaws and our declarations do not anticipate this kind of thing coming into play, we all obviously have to comply with the law and cannot tolerate noncompliance at the risk of these penalties. Once we are more sure about the implementation time, as well as the adoption of the Corporate Transparency Act to associations, and I think we're going to be more sure by the fall of this year as additional lawsuits are being filed and legislative activities going on. I think it would behoove us to adopt policies and procedures about compliance of the CTA so that when solicitations for candidacy are sent out, there is a process in place where the unit owner that is running for the board must agree to provide this information, whether it be the FinCEN ID or a copy of their driver's license and the information required. And that we have, timelines and a method for reporting and updating that information and for tasking somebody with it. So whether it be a board member or the manager or both, or the management company or an entity that the management company will eventually use to report this information. I'm not excited about handling these things for an association. It is very confusing so far. We don't really know who's going to report the information, who's going to collect the information, who's going to submit the information, and then who's going to update it, because the reporting companies will only have one login. Who's going to share that login information and who's going to keep that information, and what happens if somebody forgets that, you know, Peter resigned and Mary is now on the board, or we have a new treasurer or a new manager in place. So there's going to be a learning curve to that. But I think if you adopt a procedure and at least task somebody with the oversight of this, the chances of non-compliance will be mitigated. Once we,
Real quick. Wait,
Yes.
sorry, we have a few questions if you don't mind. So
Absolutely.
one question, why would a management company opt to use a different entity to file FinCEN information? So I think we can answer that. We at CAMCO have thousands of board members. So for one, it could be internal timing, you know, for the required deadline for filing purposes. We're also trying to determine if our software can interface with the system so that we're able to do it seamlessly through the software. So we're still internally, as Stefan said, making decisions internally as to how we're going to report and whether we assume that internally or we outsource to a third party to assist us. Next question is, how does the government use our driver's license to investigate us?
Well, that's a good question, and there's not really a whole lot of information out there. It is investigating the financial transactions. It doesn't investigate necessarily you. My guess is that they already know your name and date of birth and your driver's license number. All that does now is connected to the association. All they know now, in addition to what they knew before, is that you're a board member of an association. I think that's the only difference. You know, I'm a little cynical. I don't think there is any such thing as privacy. So they may even know that you're a board member already, but now they have a different way of gathering and keeping that information. It's not tied to your social security number or any other personal information, to my knowledge, of course, you know.
Thank you. Okay. And this is a comment. So we need a formal communication to potential board candidates that gets issued coincidentally with the call for candidates so that this is known and agreed to in advance for the locks. That will be November 2024.
Absolutely correct. And I think if you are, you know, if your election is anytime soon, I would include a statement in there about, as a board member, you know, I've seen a lot of these candidacy statements that sort of outline what you need to do as a board member. You need to attend 12 meetings and you need to be prepared to answer emails and, you know, spend some time and energy. And by the way, you also need to comply with the Corporate Transparency Act. Of course, we as members of CAI and advisors in the industry know that that is going to be a disincentive to some to run. We hope that that's not the case. We certainly make the argument that it's an additional burden on board members who already volunteer their time and energy. They now have to comply with this ridiculous new reporting requirement. But unfortunately, so far, our efforts to complain about it have fallen on deaf ears. You know, we walked around Washington several months ago and met with dozens of legislators, and basically the response was, it's just another form. Don't complain. So
Yep.
That's where we are. Again, once this is finalized and we know for sure that this is here to stay, you could make a technical amendment to the declaration and bylaws to implement this permanently. Not only the requirement to report and to be cooperative as part of a board member in good standing status. And then that is something that we can do under the Uniform Plan Community and Uniform Condominium Acts. So again, being mindful that this is out there, consider adopting procedures. I think I would put it in my cover letter now in any election for this year. And then assign a task and person in the future, of course, as we kind of learn more about gathering, updating, and maintaining this information.
And we will certainly, the manager will certainly be provided a statement from us that you can use in your call for candidates, and we'll share that with the CAMCO managers. So in turn, we'll share it with you, the board members. So that handles that question as well as Lisa's. Great question, Lisa. And then is this ID required for all board members or only for officers? I believe you're referring to the FinCEN.
I believe earlier in their slide, it includes as beneficial owners, important decision makers. And since your vote as non-officer has the same weight as an officer, I think it is all board members that need to comply with this. It's a very good question.
Very good question. Okay, and can I, as the treasurer, be held accountable for a non-reporting board member?
Excellent question. And I think that is going to go back to what is the government going to do to enforce this? How do we enforce that the declarant and declarant entity or the investor that owns 25 units will provide this information to you? And I will tell you that the best guess that we have now is report what you can. Report those officers that you can report, and submit it and update it as you can. And I think that if, of course, we are certain that this is here to stay, those board members that don't comply can't be board members. You're deemed to resign. You're exposing the association to a violation of federal law and penalties, and we cannot have you as a board member or as a candidate. Certainly, we as an association didn't make this requirement up. The person to complain to is, your legislator, but we as an association need to comply with this. I don't think that any individual board member who has made an attempt to get their other board members or their association to comply and who has him or herself complied will be subject to personal penalties. I just don't think that's going to happen. I can't see that happening. But I'm not the Department of Treasury's enforcement arm or the Attorney General. We don't really know yet how aggressive they're going to be in seeking compliance. This is a brand new requirement. I just don't think that they're going to, pull the hammer out of the garage on the first week.
Last question for right now, and we'll let you get back to the presentation. How does reporting requirements lead to gathering info about money laundering?
Your guess is as good as mine. I think they follow the transactions of the association somehow in their system and then figure out whether that money is, leaving the country. And that's why I think it's ridiculous to include associations in that. And, we have audited financial statements. We have accountants looking at what's coming in and what's going out and what's going in reserve and what's going in operating. And that for the small mom and pop shops that, I don't know, sell drugs out of the back, or instead of being a bakery, sell something nefarious and launder money through it. It's just a completely different type of crime that they're looking for. I don't have the answer for you, and I wish you were with us when we walked around in Washington and heard the responses to. We don't really care. It's just another reporting requirement, and it's not a big deal. That's essentially what we're told. It's really not a big deal. Why are you complaining?
Mm-hmm. And one final question from Russ. Did I see something where we, the HOA, have to provide HOA financial info? No.
It's not financial info. No, you don't need to disclose that at all. It's really just a corporate status information, name, address, and EIN.
Okay. We're good on questions for now. You can
proceed.
All right. Thank you.
So having said all that, in March last month, the Northern District of Alabama held the Corporate Transparency Act unconstitutional. So the FinCEN and the Department of Treasury are currently taking the position that the National Small Business United Agency or group and all of its members are temporarily exempt from the reporting requirement because they fall under this this lawsuit and the decision of that judge, which has been appealed. There are other efforts to file similar lawsuits. CAI is considering filing a similar lawsuit on behalf of its members to deem the Corporate Transparency Act unconstitutional. I don't think that that's happened yet, but it's being considered. So in addition to And by the way, this press release that I'm publishing here is directly from the FinCEN website. So it's not something I drew up. I copied and pasted it from the website. This is the announcement that it is that has made. So it only believes that the members of the plaintiff in that lawsuit, National Small Business United versus Yellen, are exempt from the Corporate Transparency Act. And that's where it stands right now. We hope that one of three things will happen. One is there'll at least be a delay and we get additional time. Two, that associations or any nonprofit corporation is exempt. And three, that there will be more of these lawsuits to deem this entire mess unconstitutional. So we're keeping our fingers crossed, and we will, certainly report back if any of those things happen. There is a slide at the end of this that'll show a little barcode or whatever that thing is called. It looks like a barcode, but it's square. That will get you
QR code.
QR code. Thank you. That will get you to the CAI website, in which you can then automatically create and send a letter to your legislator to complain about and help the grassroots efforts to make this requirement go away. But that's where we are right now. So I'm actually good on time. So before we move on from the Corporate Transparency Act, are there additional questions before I talk about Act 122?
Yeah, we did get one question. What is the legal basis for unconstitutionality?
I don't want to paraphrase it. I think what I'm going to do is I'm going to make available the decision. I have it in a PDF format. I'm going to send it to Julia, and you can read it. If you give me 1 second, I did have it on my desk. And it starts out that the federal government should, or the Supreme Court should have a rubber stamp that says constitutional but stupid. That's a direct quote from the case. And then it goes into 40 pages of constitutional analysis that I don't know how to paraphrase or explain, but I will make a decision. I'll make this decision available to you so you can read it.
And that was for Dave, so we can certainly.
It's basically a governmental overreach, and that it exceeds the powers of the legislature to govern corporate affairs. There's no national security interest in this that they have extrapolated to comply, have small corporations to comply with this. And that is a very rough 10,000-foot paraphrase of a 40-page opinion, which is actually good reading, but I'll make it available to you.
Great, thank you. We also got, will compliance lead to board members being subject to IRS federal scrutiny for them to try and follow the money?
I don't think so. Certainly I don't know exactly how this information is going to be kept, but you're giving your name and birth date and driver's license. You're not giving your social security number. I don't know if they're trying to, tie that with it. I can't see it happening, certainly not on a global basis. You're talking about millions of corporations that have to comply with this. I don't know exactly how it's possible to mine that information to investigate and find and locate and identify, money laundering and corporate theft and international money trafficking. I wish I had a good answer for you, but that's the best I can give you.
Great, that's all that we have for now. If you want to, we got one more. As long as the board members provide requested info, will CAMCO do the necessary filing for us? So yes, we are figuring out the most efficient way to collect the information from our board members. So that's something that we will, distribute an additional communication on, likely over the summer, late summer, and by the fall we'll, hopefully be ready to get everything going here. So CAMCO will take care of that on our board's behalf. We're just finalizing the process and want to make sure that, this will be a requirement for community associations, which we're hoping turns a different way, but preparing that it
Right.
won't.
We'd love to give you some good news of one of the three things. It's been deemed unconstitutional, or you got an exemption, or you got some more time. Certainly in the reverse order of preference.
Definitely.
All right. So we'll move on though. Another Pennsylvania statute that was adopted in 2023 called Act 122. Act 122 makes a number of changes to the Pennsylvania nonprofit corporation law. Was signed into law in November 2023, and it makes a number of changes including to the annual reporting requirement. So Pennsylvania used to have a thing called the decennial reporting requirement for nonprofit corporations. Every 10 years, they would have to basically update their information and say, I'm still here, I exist. So that requirement is now gone. And in its place, we have this annual reporting requirement that includes mandates for an annual report for the following. So it's any domestic business corporation, any domestic nonprofit corporation into which associations fall, and a number of others that are really not relevant for associations. But the annual reporting requirement is going to start in 2025. It is not going to start this year. What we have not seen yet is what the forms look like. So most of the Pennsylvania Department of State corporate forms can be filed, created, and updated through the department's website. And basically what happens is I can populate each of the forms. We are hoping to see what these reporting forms will look like for the domestic corporations. But at this point, they're not yet available. The reporting information will include very general basic stuff: business name, jurisdiction of formation, registered office address, name of the last governor. So that's basically any one board member usually will do. We usually give the name of the secretary or president when these kind of reporting requirements are implemented, and the titles and names of principal officers, if any. So president, treasurer, secretary, not all board members need to provide this information. And of course, the principal address. And finally, each entity in Pennsylvania that is incorporated will be issued an entity number. So that's already, you basically need to pull that, you don't create it. Enforcement of the Act 122 annual reporting requirement is actually going to be proactive. So the Department of State is going to mail notice to the registered office of all corporations that need to comply with this at least 2 months prior to the deadline. So I would expect, and we haven't seen these yet, these will be postcards. We're told they're going to be postcards mailed to your registered office that says you need to file an annual report. And hopefully that'll be a link to an electronic form that we can fill out and then submit it electronically. So what's critical for all associations that are incorporated, not only for these purposes, but for obtaining a bank loan and for service of process, is that we keep the information on file up to date, so that if and when these postcards come out, they will be sent to the correct address. You'll probably have experienced this where nobody pays attention to the articles of incorporation until you need to either open or close a bank account, or you need to obtain a loan for the association. And all of a sudden you go to the Department of State website and you recognize that the address that's being used is either the corporate address of the developer maybe, or the corporate address of the attorney for the developer, but certainly not either the management company or any board member or the association's clubhouse. So what's really important is that we all log on, or you have your management company or your attorney log on to the Pennsylvania Department of State website and make sure that the address that's listed for your association is accurate. And if it is not, it's a very simple form. It costs a couple of dollars to file to update information. Because what's happening is when these postcards go out, if they go to the wrong address, that's not an excuse for noncompliance. Does not relieve the association to make the annual reporting filing. So, but the nice part is Pennsylvania Department of State is going to let you know that you have to comply. That is not going to be something that the CTA requires. So the penalty for noncompliance are potentially dissolution or termination or cancellation. I have seen articles of incorporation and corporate names being extinguished as a result of some other failures, but most of your names are not that unique that you can't refile. That doesn't mean that you shouldn't keep your corporate status active and make these annual reporting requirements. But the penalties are not, the ultimate penalty is really not as severe as you would think. So implementation is 2025. Enforcement isn't going to begin until 2027. So while we have additional time, I think if you're going to adopt a procedure to comply with the CTA, you wrap this Act 122 compliance into it. So these are just some of the, obviously the enforcement penalties. So again, practical considerations. Verify corporate status. You may not even know that you're incorporated or not incorporated. We can find out quickly. Update the corporate status address. And again, assign a task for compliance. And I'm sure that CAMCO will be assisting you in that, especially if it is already taking care of the Corporate Transparency Act filings. So I could I could show you how simple it is to look up a corporate address if you wish, if we have a little time or you have some additional questions. The time is yours.
We have a couple questions here. So how can boards be deemed exempt? I guess exempt from the requiring the beneficial owner.
So a board is not, if the association is a reporting company, and we believe that at least for the time being, we know that all incorporated associations are reporting company, then any board member on that association board is a beneficial owner required to comply and to report or to submit the information to report. That doesn't mean that the board members are actually going to do the reporting, that the management company may be doing that for you or your attorney, but you're not going to be exempt unless your association is not a reporting company. I hope that's clear.
Okay. The other question, what if a board member does not want to share license or passport info with CAMCO? And I know you spoke about that early on. So if that is the case, then you would apply for the FinCEN ID directly. And we will share that information as we approach and ensure that you have to apply for one, that this is moving forward, as Stefan said. Do you know what person in Congress created this?
I would have to look up the sponsors, but I think great question. I'll look that up and get it back to you. I don't know the answer.
Thank you. All right, that's all questions for now.
Okay. Well, we have a bit of time. I can show you what the FinCEN website looks like and what the Department of State looks like. Let's make that easy. Let's see if that works. If I pull this over, am I still sharing my screen? Can you see that now? So here's the Department of State website. The link is in this presentation. And in order to look up a business name, you really just click on here on businesses. Business name search. And then you type it in. You'll find out if you are incorporated and whether or not the correct address is shown. So if you're willing to provide me with the name of your association, I'll type it in and we'll find out what the address is. public information, so I don't want to embarrass anybody, but give me the name of an association and I'll look it up.
The ridings, so the ridings at Chesterbrook.
Yes, it is a incorporated association, incorporated in 1981. And it looks like it still has the association's attorney at its address. I don't know that that's, yeah, Barlow and Associates. No, that's a management company, a former management company. So if you want to reach out to CAMCO or your attorney, very simple to change this address to wherever you are now. So this just illustrates that we have found out that you are incorporated, because you may not be, but in this case you are, and that this address is most likely outdated. It's not unusual. I would say 9 out of 10 associations that I look up have an outdated address, because it's just not something that is on the radar of an association.
Right.
So if I were your attorney, I would click over here to request access after I log in here, and then I could file this electronically within about 5 minutes, and then your address would be updated. So really not a difficult task. So if you thought it was really complicated, it is not. And let's go to the FinCEN ID website. I can show you what that looks like. Didn't want to go there. There we go. Okay. So this is what that website will go to. And this is how you create a FinCEN ID for yourself. You sign in or create an account. You hit this website here. This gets you to login.gov. And then you create an account. Once you hit create an account, you create an email address and a password, and it asks you for those 4 pieces of information: your name, your address, your birth date, and a copy of one of the identifying pieces of paper documents, driver's license. And once you do that, it will send you an email with a 12-digit number. And that's it. That 12-digit number can then be used for you to report. So when CAMCO or the entity that CAMCO is going to be using for the reporting asks you for your information, you say, I don't need to give you information. Here is my FinCEN ID. And once they have that ID, CAMCO doesn't even need to put your name in there anymore. So I will tell you where that is, just to dispel some of this this fear. I believe, let's see. See how fast my computer is tonight. So this is the filing website for FinCEN, and you can file electronically completely, or you can populate a PDF to file electronically. But this is where I think most associations and these companies and how we're going to do it. But you click on the filing here. File BOIR, prepare and submit. Of course, you have to agree whatever those terms are. And this is what it looks like. This is the beneficial ownership and the filing information. So it's the filing information for the reporting company. And you can also request a FinCEN ID for the reporting company. But I guess we're getting into the nitty gritty. But I just wanted to show you as beneficial owner. So the thing that board members are concerned with, whoever's going to file that is going to click on beneficial owner and needs to complete this. And there's 2 ways of doing it. And one is you add for each beneficial owner this 12-digit number. That's it. Don't need to put in a name, an address, a birth date, or anything else. It's just that number. And of course, the other way to do it is to populate all of this information: name, address, and then identifying, and then you upload it into this system. But the simple way to do it, not only for CAMCO or for me, or for you is to just provide that 12-digit number. And that gets populated here, and it doesn't even require that your name is input. So that's pretty much as complicated as it is, and that's probably why the legislature is telling us it's just another form and just another requirement. But in any event, I don't want you to quit and run because you have to provide this information. Now, it's really, you know, it's not something I'm going to say to a legislature, but it isn't as big a deal as we would make it. I think it's if it stays, it's going to be another reporting company requirement, and it just is what it is. But here is we call it a QR code, right? So I don't know if this will work with your phones, but it should. I don't know if you're going to distribute a copy of this.
We were going to ask you.
Presentation.
if-
Absolutely, you can.
Okay.
Oh,
So
yeah.
that's,
Absolutely.
yeah, so we will be, by Monday, the 15th, we'll send a follow-up communication, both with a recording of this, presentation and a copy.
Yeah, and
presentation
I'll
attached.
send you a copy of the reported decision in the Yellen case.
Great, yeah, thank you. So
But
we will circulate that to all of our board members. So if your fellow board members were unable to attend this evening, they'll be able to watch the presentation, and you'll also receive a copy of the presentation.
So any other questions before the hour is up? I was pretty punctual here. It's 6:59.
You were, thank you. Parting comment from Russ. Politicians say it's just a form for now.
Yep, I agree.
Yeah.
Very true, Russ.
I'm with you.
Mhm.
I'm
So-
with you.
Yeah, well, we really appreciate your
Yes.
time, Stefan. We appreciate everybody who joined us this evening. We had a great turnout. You know, we wanted to, there's definitely been, the word's been spreading around. We wanted to make sure that our board members had, you know, the most up-to-date factual information that we could provide, and we'll certainly follow up with additional communications.
Yeah, and I hope to be able to provide good news in the next couple of months, but, you know, fingers crossed. But until then, you need to be prepared to comply.
Great.
Thank you
Very
again.
good. Thank you again, and
Hope
have
everyone has a
have a-
great evening.
great evening. Thank you again. Bye-bye.